Good morning and welcome to the June 29th edition of Bar Talk. We've got a lot of important stuff to share with you that sort of bringing us all up to speed from what happened last week. Now, one of the things that I wanted to share with you last week, but for some reason I totally blanked on, were judge reassignments. I just happened to receive a letter drafted by Judge Ramonde that announced a number of reassignments in the district court realm. And one of those is Judge Brett Davis has been reassigned to Augusta. Judge Eric Walker has been assigned to Belfast. And he'll work with Justice Billings for that regional scheduling that will occur between, the Superior Court and the district courts as it relates to the combined or the unified docket. Also, Judge John Martin will be the new district court judge in Wiscasset, Lincoln County. And Judge Ramonde will be the new sitting judge in West Bath. Judge Archer, who was sitting in West Bath, is moving to Lewiston. She'll be sitting in Lewiston. Judge Montgomery is going to be in Farmington. And Judge Carlson, who has been in Rumford and Farmington, is going to be retiring this month. Also, Judge Charles Dow is going to be moving his office or seat from Lewiston to Waterville. And those are the changes that I know of just in receiving information to share with you. And if there are any other changes that you all know of, you can please share them on chat and we'll share them with the rest of the group today. For those that don't know, the law court did invite us to submit amicus briefs related to a child protective and guardianship case by July 13th, that it's hearing that it already has briefs submitted on by the parties, but is seeking amicus briefs. And I think what this relates to, if anyone has not run into this, you probably eventually will if you get into this type of work, is that district courts in the last couple of years have started hearing guardianship cases for children, minor guardianships. And because of that, some child protective cases have been joined with these guardianship cases. And I believe the law court is going to be deciding or considering the important issue of how these two cases types of cases actually work together. In other words, should a guardianship that is petitioned for under the under the guardianship rules and statute take precedence over a government filed protection case and placement of a child. So that's just a little bit of the issues that probably the law court is facing. And that's just my opinion only, no attribution here. And then on, yes.
There is a note here in chat that said they have to be under the Home Court Act.
For the district court to hear a guardianship case, you're saying? I believe yes. In other words, there has to be something that's filed in the court, in the district court, in order to, that's like a child protective case or a protection from abuse case or a parental rights case. It has to be something that keeps, that would give the court jurisdiction. Yes. Thank you for that comment. And on June 26th, was just last Friday, the governor announced that she's, or the her administration is handing out $9 million in grants to nearly 100 Maine's cities and towns for COVID-19 prevention efforts. And I think we provided a link for you there to go check that out if you'd like. On June 25th, Governor Mills announced that she was funding this commission that she actually had stood up last year on the status of racial and indigenous and Maine tribal populations. Previously, according to the press release, I think it had only been funded with $500. Now she funded it with $50,000. So you can also find that on her press release page. And that's good news for education related around race. So that's good news for everyone in Maine. On June 22nd, the governor also sent out a press release holding back on opening Maine bars effective July 1st. So that's a setback for socialization, but keep in mind there is a lot of variation related to dining outdoors, and I hope everyone here has been able to take advantage of going to an establishment and sitting outdoors and taking in the beautiful weather we've been having. And this rain is good for us too. So if is there any more in the chat line about what we talked about, Angela? No. Okay. So one of the things we're going to comment a little bit about on the business side is everything that's occurred in the last week. And I see my speaker might not be working that well, but so we had a Board of Governors meeting last week, and we addressed a lot of issues. One of those was the work of Jonathan Dunnett's committee that had been set up to deal with pandemic issues. And I'd like to introduce Jonathan. I think he's spoken before on Bar Talk, in particular about the proposed amendments that we have voted on. We voted on last week to forward to the judicial branch, and that's regarding PMO SJC2. Jonathan, can you give us just a brief of the points that we're recommending be amended?
Sure thing. The first thing that we recommended was that it have an end date of October 31st of this year unless amended by the courts, because there was some concern expressed to us that the order would somehow find its way into the rules, and we want to ensure that remote depositions are not the default requirement under the existing rules. The next issue that we dealt with was that the rule provides that remote depositions are the default, that they're required. All depositions shall be remote. The order also provided that you could file a motion within 3 days of receiving notice of a deposition, asking that it be conducted somehow other than remote, either with everyone in person or the attorney filing the motion being in person. And there were two issues with that. One was that it only expressly provided that the party receiving the notice could file that motion. There was no mechanism for the person noticing, the party or attorney noticing the deposition, to move for it to be other than remote. So we provided a mechanism both for someone receiving notice of a deposition and for someone noticing a deposition to file a motion within 3 days, explaining why it should be conducted. It should not be conducted remotely. Another issue with that was that although there was a motion that allowed for motion practice, the rule also said that an objection to a remote deposition would not stay the deposition. And since you had 3 days, the party has 3 days to oppose a motion or to file the motion, then the opposing party has 3 days to sorry, you have 3 days to file a motion after you receive notice. Then you have, the other side has 3 days to oppose. That's 6 days. And according to the rules, you can notice a deposition with 10 days notice. And while we recognize that typically it's an agreed upon date and they're usually more than 10 days out, there is some concern that a deposition could occur while that motion was pending, forcing an attorney who had a legitimate objection to it being done remotely to do the deposition remotely, in which case that there's no way you can cure that prejudice. So we deleted that provision that it would go forward, but we also recognize the concerns from the proponents of the order that they were having troubles with depositions being delayed by attorneys who were just refusing to do them remotely. So we included in the rule that if the court denied the motion prior to the date of the deposition would go forward on that date, or if the court granted the motion, but it could still be conducted in person on the date scheduled, it would go forward. And that way, simply filing a motion would not be a basis for removing the deposition from your schedule or your calendar. And so we're trying to encourage the depositions to go forward, but allow for the ability to object and have that objection heard before the deposition goes forward. And that was probably the most controversial of our changes. We also had some additions to the rule that indicates that the deposition would occur in the place where the deponent is located, because there were some issues with if, you know, I'm taking the deposition and I'm in Maine, opposing counsel is in Bangor, court reporter is in Augusta, and the deponent is in Florida. You know, there's some questions about where that deposition is occurring. So we wanted to make sure that that was clear. And then another addition was to encourage the parties to discuss documents ahead of time, because these are somewhat, you know, it's somewhat difficult to handle the documents. You know, when you're sitting in the room with everybody, you kind of hand them out to everybody as you go. But it's kind of more complicated when you're doing it remotely. And so it's not a requirement that you exchange documents before the deposition, but the rule does encourage people to do that so that the depositions will go more smoothly. Those are the major changes. There was also one that we just added, that if you're going to do this as a video deposition, you do have to have a videographer there in person unless the parties agree otherwise, so that the remote depositions don't become an adjunct for using the video of a remote deposition as a video deposition. And those additions that we added were based on the Massachusetts Supreme Judicial Court's order regarding the same issue. Thanks, Thad.
Thank you, Jonathan. And on the business side, Angela, what did you have to provide us with or add into what we've done last week?
Before I move on, I did have one question. Did the committee incorporate the Maine Uniform Interstate Deposition and Discovery Act?
We did not, but I will research that and see if it was incorporated inadvertently, or if not, then we will get the ad hoc committee back together and see if we can add that.
Jonathan, Paul Chaikin's on that committee for the Bar Association, and
okay.
that uniform works, so I'm sure he could be helpful to you.
Okay, great, thanks.
That's great, Paul. Thank you for speaking up. Go ahead, Angela.
So one of the other things that came out of the board meeting last week was we've put together an ad hoc diversity committee, and the reason it's ad hoc is because it's eventually going to become a permanent committee, but part of what we want this initial group to do is to figure out the bylaws and the name of the committee, the final name, and its goals, and the board did give some charges and things, things that it wanted the committee to look at, but we wanted the committee itself to come up with some of the work it would be doing. So that is moving forward. That committee will be meeting this week. Currently, that committee has 6 board members and 6 attorneys from different areas of the state, and that we reached out to and asked to be on the committee. And that committee's makeup will probably change going forward a little bit, but for now, we just wanted a group that was manageable and could provide some initial feedback and recommendations to the board. So we'll keep you posted on what's going on with that. There will be no bar talk a week from today on July 6th. I've given my staff that day off, and it's been a crazy few months, as everybody knows, and a crazy few weeks as of late. So we're gonna take the day off on Monday, and we wish everybody a happy Independence Day, and hope you have a very safe and enjoyable one with your families. And hopefully, although we need this rain right now, keeping my fingers crossed for some good weather. I haven't looked that far ahead yet. And then we'll be resuming back on Monday, July 13th with Bar Talk. Justice Mead will be joining us to talk about the planning and implementation of phase 3 in the courts and how that's going and where they stand with that. And Lori LaChance, I won't be there that day. Heather will be taking over reins because I'll be dropping my daughter off at school that day for college. So hope everybody has a good time that day. I'll be traveling to and from New York. And then Lori LaChance, who is one of the co-chairs on the governor's Economic Recovery Committee, will be joining us on July 20th. And their initial report to the governor is due July 15th. So we're hoping she can provide us the information on what they gave to the governor on the 15th at that point. Any questions? I don't see any.
All right, so one of the things I'm going to do is just add on and piggyback a little bit to what Angela had said, and maybe there'll be some more questions too. So the diversity committee was actually given a number of charges, and a lot of those are embodied in a press release that we did release last week. Correct, Angela? Yes. And so you can find those on the press release, which is on our website, I'm sure, for you to take a look at. The other part of what we handled at our Board of Governors meeting on Wednesday, June 24th last week, was addressing an opening that we have in the Board of Governors. We have a governor position that is open in Kennebec County because of a resignation. So for anyone listening here that has an interest in that opening or has someone that they'd like to nominate, they should forward that nomination request to Angela, who will get it to our nominating committee, who is currently working on filling that position as we speak. The other thing that we should let you know is that we've been speaking with the judicial branch about delivering a series of electronic filing CLEs. And in that process, we have garnered some new information about what it is that the judicial branch has lined up for us in the Penobscot and Piscataquis County district. And that is essentially a switchover beginning on, was it October 6th, Angela? October 5th. They're actually going to shut down in September the receipt of paper filings in the areas of I just had it here.
It's family law matters.
Yep.
And the BCD.
Yep.
And one other area. No criminal. My notes, I don't know what I did with them.
Right. So for a 2-week period, there'll be essentially no filings permitted during,
In family law cases, BCD.
right, the civil docket, family docket, and BCD. So on September 25th, they're going to stop receiving paper filings in those areas. And then on October 5th, they're going to start with electronic filing. So it's happening. And we are working with them to bring you education on the electronic filing rules, as well as the electronic filing itself. And that process we expect to start in August. So it's kind of exciting.
And let me just add that one of the other changes that happened, because they were originally going to roll out all the cases, and that's just been with the change in leadership and then the COVID stuff, it's kind of changed how their focus is. But it is going to be, come October 5th, will be mandatory for attorneys, but it will not be mandatory for pro se litigants. So.
All right. So those are the updates that we've got for you and on the personal side, of course, I'm just able to reflect over the course of this weekend, which was absolutely beautiful, of how lucky I am to live in the United States of America, to be born here, to be raised here, to have all the rights and privileges and opportunities that we have in this country. And I'll be reflecting on that for the rest of the week as we turn into the 4th of July. And I'm happy to be a part of everything we are here. Thank you for tuning in. And remember, July 13th is our next Bar Talk, where we'll have on the Chief Justice and go forward from there. Is there any alibis, Angela, or are we good?
The only other question was the dates of September 25th and October 5th. Will that be all of Maine or Penobscot County? And that is, it's actually Region 5, which is basically Penobscot County, but there's, I want to say there's
I think it includes
in there as well.
Yes, I think it includes that county too. Yeah. All right. Thank you, everyone.
Bye-bye.
Have a happy 4th.